May I just say this, my Lord Justice Bhatt? When I speak at different events around this country, make it a point to speak in small towns, India. And I make it a point, and young people in our country want marriage. I don't say this as an elite lawyer. I say this having met these young people. Do not let them experience what we have experienced. Every study indicates that in countries where there is marriage equality.
Dr. Guruswamy, there's a problem with this line of argument.
No.
I'll tell you why. We understand the feelings out of which this argument comes. But at the constitutional problem, at the constitutional level, there's a serious problem. If we go by what young people feel as a constitutional court, then we would be subject to volumes and tomes of data on what other people feel. Now, therefore, the great salutary safeguard of constitutional adjudication is that the court has to go by what the Constitution mandates.
Correct.
And therefore, we don't go by
Yes.
either popular morality or a segmental morality. We decide what the Constitution says.
But this is...
Because the moment you say that this is what young people feel, I'm sure there'll be people on the other side who are willing to throw tomes of material at us what the country feels. Let's not get into it at all.
My lords, this...
Therefore, what we were suggesting was this. We get your point that you seek a right to marry. You are also conscious of the fact that a mere declaration of a right to marry is not adequate in itself unless it is implemented by a statutory provision which recognizes, regulates, confers entitlements on those who are married. Therefore, you are conscious of the fact that the implementation of the right, the achievement of progress on the ground depends on whether there is a statutory framework for implementing that right. And therefore, you say located in Section 4. We'll consider that argument. But as we said, suppose we were to come to the conclusion that this argument is not as simple as it appears to be, that there are too many interlinkages with other statutes, including personal law, which we would be treading upon, and perhaps which would lie outside the domain of judicial review. Then what? Then our concern is that, look, everything has to be something which you achieve in incremental steps. This is a social institution. That social institution is also evolving over a period of time. But the court can ensure, by acting as a facilitator, that real progress is achieved today in terms of a wider societal acceptance of the right to cohabit together. Whether we go as far as to recognize the right to marry for couples who are not heterosexual couples is a separate matter. We'll be dealing with that. We are not shutting the argument to you. That's why we are hearing this side. But even assuming that we don't, we do, that's the end of the matter. But if we don't want you to be in a situation, or the movement to be in a situation where there's nothing else then available in hand, that this matter then goes. That's not the way we are couching this, this dialogue.
See, the